All right, you are Ebony Broussard,
Correct.
and
Yes.
this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation in the 32518 and 32806, was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer, and then was placed on probation July 12th of 2021 in the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor, everything that we have in there is very direct in support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimler.
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them. So that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering the developer to consider something at the lower end. She does have children, and I'm not trying to use that as an excuse or anything, but I think it maybe perhaps
Children she was on her way to get while she was under the influence of PCP.
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she does.
Played true to all of the counts.
But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be probably, I'm looking probably incarceration, but I would just ask that it be something not extreme, or at the upper end. And she wanted to address the court. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before, and if you will be willing to work with me again, I would appreciate it. I have, before I was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I got assessed. And I was taking AA classes as well. I did complete 5 of the classes. However, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my.
So is the time, it was told, I mean, because of the motion. So yeah, I mean, you did the 5 years, but
Yes,
it's not over.
yes, ma'am.
What is, Ms. Malfino, do you have any position with regard to specifically punishment on these cases?
Sorry, Judge, I was just looking back at the original PSI. I do, thanks. Obviously, the court sees that she doesn't prior to this have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
So, Ms. Broussard, you've been given the opportunity of, it looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium case.
This is the moment where the hearing changes completely. Judge West carefully reviews the defendant's long history of treatment programs, probation supervision, drug intervention, anger management, and previous rehabilitation efforts. Instead of focusing on just one mistake, the court evaluates a consistent pattern over several years. In probation revocation hearings, judges often look at whether previous opportunities successfully changed the defendant's behavior. Here, Judge West explains why those repeated chances matter when deciding punishment. At the same time, the defense argues that addiction remains the underlying issue and asks the court for leniency. What do you think? After years of treatment and multiple violations, should rehabilitation continue, or does accountability require a prison sentence? The answer comes only moments later.
And you're still using. So at this time, in clause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. And at this time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And clause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody that the law gives you the right to receive. And then in clause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Right hand. And what is the statement? And I'll wait on that.
It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that.
When do you find
You hand her that one and just the bottom copy off of that one, Mr. Kimler.
After considering every argument presented in court, Judge West concludes that probation has failed to achieve its purpose. The court revokes probation, finds the allegations true, and imposes prison sentences that will run concurrently, while also explaining the defendant's remaining legal rights, including the right to appeal. Throughout the hearing, Judge West emphasizes that the decision is based not on a single incident, but on years of unsuccessful rehabilitation efforts and repeated probation violations. The case serves as a powerful reminder that probation is an opportunity, but continued noncompliance can ultimately lead to incarceration. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
Good morning. Are you Leroy Harris Jr.? And this is cause number 24 DCCR 0404. Mr. Harris is charged with a first-degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in 2 cases on that same day. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the murder case with a dismiss in the pending felony. What pending felony is there?
Drug case in there somewhere.
Well, that's the
It's an
MTRP.
MTRP.
So really wouldn't be a dismissal of it. It's just the MTRP on a state jail
I
felony. It
like
looks,
this.
well, so I'm going to mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30.
30,
Yes.
not 40.
Correct.
So is it, okay, so Mr. Harris,
I don't think it makes a difference, but just the paperwork.
so the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket and Mr. Burbank will begin preparation for trial.
Thank you, Anna.
Thank you.
Is that,
Yes.
And Judge, just may I, for the record,
Yeah, hold on just a second.
why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank, but it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you.
Thank you.
All right, you can go back with the bailiff. And then you've got Asa Jones, Mr. Burbank.
yes, sir. I think we previously had.
Yeah, this is pretrial for Monday.
Judge.
Morning, Mr. Coleman. Mr. Coleman, I've heard some
I know, Judge. It's unfortunate. I'm a team player.
some
Judge.
very unfortunate news.
Team player. I go where the coach.
I don't like that team.
I
I
go,
like the team I've got right
I
now.
go where the coach tells me as a member of the team.
Team is being downsized.
The team is being downsized.
Sorry.
Right, sir, you're Asa Jones. And this is cause number 25 DCCR 0963. Mr. Jones is charged with a first-degree felony offense of aggravated assault. And the case is set for trial to begin with jury selection next Monday. And what is the announcement?
You should be ready to.
Station ready.
All right, it is likely going to be at the top of the list. I have one other that's potential, but it sounds like there might be some issues. So, but you'll know today after docket. I do want to make sure you understand, Mr. Jones, that after today, I will not accept any plea agreements. It looks like I've got a plea bargain rejection from January of this year where you rejected a 25-year term. Has there been any change in negotiations?
No, Judge. Your Honor, we have a witness that would ask the court call the name of, please.
Okay,
Atlanta Gallo.
Atlanta Gallo, please.
We asked that the court admonish her, she's under subpoena, admonish her about the consequences of not showing up for the trial next week.
If you'll just have her come over here on this side. Good morning, ma'am. And your name's Atlanta Gallo?
Yes, ma'am.
And Ms. Gallo, we're here in clause number 25, DCCR 0963, and Mr. Jones' case is set for trial for next week to begin on Monday. You are placed under subpoena for that, and I just want to make sure you understand that it is required by law that you show up whether you want to or not for court next week. At whatever time the district attorney tells you and whatever time that subpoena told you, you have to be here. If you don't come, now that you've been given this order and that subpoena, there could be some consequences where you would get in trouble. Do you understand?
Yes, ma'am.
You could be held in contempt of court. There would be a fine. You could potentially go to jail yourself for not showing up. Do you understand? Okay. All right. You're free to step back out.
Thank you, Judge.
Excuse Judge.
All right, anything else then? So, Mr. Jones, I do want to make sure you understand that after today, I will not accept any plea agreements. And again, it's very likely that your case will be at the top of the list. Mr. Burbank will know that after docket today. Do you understand?
Yes, ma'am.
Okay, I'll let you know after docket then.
I have excuse Your Honor.
Yes, sir.
Been about that. I thought to him.
Ms. Perazzo, you've got Logan Eaglin,
Logan.
Mr. Smith.
Logan.
Good morning.
Sorry, Carmen. I got his. Still yesterday. Yes. Yes.
Good morning. Are you Logan Eaglin?
Yes, ma'am.
And this is cause number 26 DCCR 121123. Excuse me. Mr. Eaglin is charged with murders. Case is set for trial to begin with jury selection next Monday. What is the announcement?
Your Honor, so there is some additional discovery that was just provided to me, and I have not had a chance to review that with my client. So I would like just one more brief reset so I can visit with him and go over all of that discovery.
So I guess my question is, if it's just going over discovery with him and making him aware of all of that, then I feel like that's something that could take place soon, today, go over everything. If there's any change, y'all could let me know, unless there's some other investigation or information that you're still waiting on or you need to find out.
No,
Okay, well, do you want to?
there is, I mean, it was, an additional witness has come forward, that, this defendant has made a admission to, about committing the crime. But it is another inmate, so we would, I don't know, I think if they want time to investigate that, maybe even having to try to interview him. State would not be opposed to that, we're not opposed to resetting it one time for trial.
Is that your intention?
Yes, Your Honor.
Okay, so I'm going to, and it was also, it looks like it's been re-indicted. This is the third re-indicted.
Yes, Judge.
So, which, I mean, the information that you have is all the same other than the new information that you just got yesterday, is that
Yes, and
correct?
then I also got some new media yesterday in this case.
So here's what I'm going to do. I'm going to reset the case 45 days on an announcement docket. That way, if there's any change in, well, actually, I'm just going to reset it on announcement 30 days. If you need an investigator, you can get that, make that request
Yes,
quickly.
ma'am.
We'll get you the funding for it. That way, if they need to go visit with any additional witness, let's try to get it all done within 30 days. If something changes and there's some deal that we reach on the 30th day, great, then we'll take care of it. If not, it'll go right back on the trial docket at that point instead of us waiting 3 months for another trial docket.
Yes, ma'am.
Okay, all right, you can go back
Thank
with the
you.
bailiff. And then you got Thaddeus McCray.
Yes, ma'am.
Can you make a note on either line? When I look up the new clause number, none of the old that has been brought into that new clause number. So I don't put any of the objections or anything in their way for all, I need everything to be transferred to the new case. And it's probably from those two prior, not just one, but two prior indictments.
Roughly.
All right, sir, you're Thaddeus McCray. And Mr. McCray is charged in cause number 26 DCCR 0399 with the first degree felony offensive murder. And in cause number 21 38959, we've got a motion to revoke probation for an aggravated assault causing serious bodily injury. And what is the announcement?
Your Honor, essentially it's the same announcement that I just made previously on the last case. There were some items that were missing from discovery that I requested. They were just recently responded to and provided. I'm not sure if everything that I asked for was provided, but I need to review all of that and go over that information and evidence with my client just
Okay.
to ensure that we have everything.
Sure. So we'll do one more reset. Is there anything else that you know of that you're waiting on that she does not
No,
have?
Judge, these were things that she had asked for that weren't in the file that we went and got.
Good,
and brought
okay.
into the file.
So, Mr. McCray, I'm just going to reset your case, a normal reset for about 30 days. That'll give Ms. Peraza some time to come go over all of the new information that she's received. At that next court date, we'll need an announcement whether or not you're going to go to trial or if there's some deal that's reached, okay?
All right.
All right, thank you.
Yeah, what's the good?
Mr. Rojas, you got Jaden Brantley.
Brantley, Jaden Brantley.
Okay, so she's they did work it out. So, Mr. Kimler, Ms. Holmes is going to take care of
Yes,
that
ma'am.
for you. Okay,
I've
perfect.
told them that.
Okay.
I had told the advisor.
Thank you. Good morning. Are you Jaden Brantley?
Yes, ma'am.
And this is cause number 26 DCCR 0422. Mr. Brantley, you're charged in that case with the first degree felony offense of aggravated robbery from February 6th of 2026. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And if I follow the agreement, I cannot give you more than 25. I could give you 25. I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer, have a jury decide if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to a jury trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
Do you want to set up a trial?
Do you want to visit with Mr. Rojas again?
You talk some more?
Okay, I'll hold it. And if you need some time to go out and visit, just let me know. I can give you a week or two, but I'll hold it for a little bit.
Yes, ma'am.
All right, go back with the bailiff. And I'm just I'll have that on here.
Okay.
If you still want it, it'll be here. You got Manuel Cardenas. It's a sentencing, Mr. Rojas.
Yeah, Friday. You've been saying you Friday. Great love.
Good morning. Are you Manuel Cardenas Jr.? And Mr. Cardenas was previously in court, entered a plea of guilty in cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Sr., your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Okay.
Mr. Vasquez, you have Corey Como.
Me?
Oh, I just saw him. Did he go somewhere? Well, don't call. I don't know where Joel is, so I'll skip that. Let's see. Mr. Rojas, you got Jimmy Couch.
Couch.
You're here for Bruce?
Yes, ma'am.
Okay, I'll take care of that. Just a second.
Okay.
Yeah, I know that. There you go. How you felt? When you don't see. You do not see it.
This is computer stuff.
Good morning, Judge.
Good morning. Are you Jimmy Couch?
Yes, ma'am.
Y'all give me just a second. I just don't know.
Okay. We're gonna like a statue. We can know that it's attempted.
Yes, well,
That's coming. Mr. Couch,
Yes, ma'am.
pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'll be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues. And that will be the position of the state to ask for safety. And I'm afraid that if he's out in the interim, it will derail that and also this absence of contact with her at this point.
So
I understand that's the state's position.
Sure.
Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for
4 months
4 months. He's getting some taking AA classes in jail.
from Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
get addressed.
I have a spot on my lung. I was supposed to be in Baptist Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
Well, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do go ahead and get a substance abuse assessment during that so that we have everything in place when we come back for sentencing. All right, you can go back with the bailiff.
Okay, thank you.
So on Bragan Hulsman, that's the one you talked to me about, right?
Yes,
Mr. Did y'all,
we did.
oh, okay, sorry.
Yeah.
Actually, gonna be a misdemeanor since he did it.
You go.
Good morning. Are you Bragan Hulsman? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26 DCCR 0199, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, sure.
Do you fully understand them?
Sure.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number 1.
No objection.
It's admitted. And are you a U.S. citizen? All right, is there any evidence that Ms. Hulsman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Hulsman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back. John McMillan. Mr. Rojas and Ms. Muffino.
Hold on that for 1 second.
Sure. Well, call, I sent a letter, I need to go kind of grab some people that.
Okay, I'll hold it. Ms. Shipley, you're here on Brandon Lewing for Mr. Smith.
Yes, Your Honor. Brandon.
Morning.
Good morning. But I feel
And they take you down right now.